5 seconds to go. Start. We thus hold that when the corporation takes steps for recovery of the amount by resorting to the provisions of Section 29 of the Act, the limitation period for recovery of the balance amount would start only after adjusting the proceeds from the sale of assets of the industrial concern, as the corporation would be in a position to know as to whether there is a shortfall or there is excess amount realized only after the sale of the mortgage hypothecated assets. This is clear from the language of subsection 1 of section 29, which makes the position clear that where any industrial concern which is under a liability to the financial corporation under an agreement makes any default in repayment of any loan or advance or any installments thereof, or in meeting its obligations in relation to any guarantee given by the corporation or otherwise fails to comply with the terms of its agreement with the financial corporation, the financial corporation shall have the right to take over the management or possession or both of the industrial concern, as well as the right to transfer by way of lease or sale and realize the property pledged, mortgaged, hypothecated, or assigned to the financial corporation. Even otherwise, it must be mentioned that the division bench was in error in stating that the right to personally recover the balance terminates after the expiry of 3 years. It must be remembered that the question of recovery of balance will only arise after the remedy in respect of the mortgage deed has first been exhausted. It is a mortgage suit was to be filed, the period of limitation would be 12 years. In such a suit, a prayer can also be made for a personal decree on the sale proceeds being insufficient. It is thus clear that merely because the corporation acted under Section 29 of the State Financial Corporation Act did not mean that the contract of indemnity came to an end. Section 29 merely enabled the corporation to take possession and sell the assets for recovery of the dues under the main contract. It may be that only the corporation taking action under Section 29 and on their taking possession, they became deemed owners. The right to claim for the balance arose under the contract of indemnity only when the sale proceeds were found to be insufficient. The right to sue on the contract of indemnity arose after the assets were sold. The present case would fall under Article 55 of the Limitation Act 1963, which corresponds to old Articles 115 and 116 of the old Limitation Act 1908. The right to sue on a contract of indemnity guarantee would arise when the contract is broken. Therefore, the period of limitation is to be counted from the date when the assets of the company were sold and not when the recall notice was given. The upshot of the aforesaid discussion is to hold that the present appeal is bereft of any merits. Upholding the judgment of the High Court, we dismiss the instant appeal. Stop.